I'm reading number 670 on AnnaVonReitz.com, the first instruction letter by Anna von Reitz, scan copy to be posted on the website, letter to Trump, Mnuchin, Sessions, and Judge Thomas Hogan, and Royce Lamberth, dated July 17, 2017. Dear Mr. President and Mr. Secretaries and Honorable Judges, we will quickly summarize how we arrived at the current situation so that you have the necessary background to comprehend our position. Please read on. And this essay starts with the Sestakv Act of 1666 and takes us all the way through to present day. So it's probably the best history of the bankruptcies and the fraud perpetrated upon us that I've ever seen. And I encourage everybody to get several copies of this and get acquainted with your history so you know what's gone on and so that you're not doomed to repeat it. Number 1666, the Great Fire of London creates the occasion for the creation of individual public trusts as a means of seizing private property. The Sestakv Act of 1666. 1702, the British Crown and the Dutch East India Company collude under Maritime Wagering Act. Living men are deemed to be vessels and insured. Their death and loss becomes a means of enrichment for the commercial corporations and the British government. 1765, the pollution of English common law with admiralty law to create equity law, granting absolute power to the judiciary to seize upon and distribute private property, comes to fruition in England under Lord Mansfield. 1776, partly in objection to this usurpation of power by the judicial functionaries, the American colonists rebel. 1819, the American states passed the Titles of Nobility Amendment to the original Constitution, putting teeth and penalties into earlier provisions, effectively prohibiting members of the bar associations from holding public offices. 1822, the then Pope and then British monarchs secretly collude to act in breach of trust against the Americans and sign the secret Treaty of Verona. 1837, the British Settlement Act sets aside public wastelands as commonwealth, and paupers are said to be settled upon this land, thus becoming wards of the state. This effectively prevents the lower classes from ever being landlords and provides a basis for claiming them as chattel property. 1858, Benjamin Disraeli begins to push the enfranchised British laborers as properties belonging to the British Crown. They and their assets are seized upon in the process as collateral backing government debt. Their voluntary enslavement is used to fund the British Raj in India, though they are never told any of this. In 1860, Abraham Lincoln, a bar attorney, is elected president. He can only serve in the private office of the President of the United States Trading Company, not as President of the United States of America, as a result of the Titles of Nobility Amendment. He contrives to start the Civil War, which is never declared by Congress. 1863, Lincoln succeeds in bankrupting the United States Trading Company and issues General Order 100, placing the Grand Army of the Republic in charge of the government. The entire war is an illegal commercial mercenary action resulting in a military dictatorship being established in the District of Columbia. 1865, Lee surrenders his army to Grant at Appomattox, but no official peace treaty is ever signed. The southern states are carved up into 10 military districts, and all the original states are improperly subsumed into the bankruptcy of the United States Trading Company by a process of Assumpsit. 1868, the creditors of the United States Trading Company issue a look-alike, sound-alike corporate charter called the Constitution of the United States of America. This creates a commercial corporation merely calling itself the United States of America that then substituted itself for the actual government owed to the people and states of this country under the Constitution for the United States of America. 1868 to 1875, this new government entity then forces the original unincorporated state governments to write new state constitutions and to assume new doing business as names in the form of Wisconsin State, Connecticut State, and so on, while seizing upon the name of the original states and operating territorial franchises for itself under their names, State of Wisconsin, State of Connecticut, and so on. All these semantic deceits are pulled off on the trusting public. 1907. The 1868 version of the United States of America Incorporated is bankrupted. The land of the actual states and people is unlawfully seized upon by the creditors of the United States of America Incorporated as collateral backing its debt in bankruptcy. Title is taken to the land and the actual patents seized upon, with the creditors receiving the equitable title and benefit. 1930 to 1934. A second corporation calling itself the United States of America is bankrupted. This time, FDR unlawfully converts the entire population of this country, reinterpreting our trade names on the land to be foreign situs trusts operating in the international jurisdiction of the sea. This allows the creditors of the bankrupt, private, mostly foreign-owned United States of America Incorporated to seize upon the labor and other private property of Americans in gross breach of trust owed to us by the popes and by the British monarch. By this deliberate fraud, we are presumed to be commercial vessels belonging to the bankrupt United States of America Incorporated, and by process of extortion and Assumpsit are forced to pay its debts. We are also considered missing, presumed lost at sea. Ancesta KV trusts are established by the municipal United States in our names. These things are operated under deceptive account designations that appear to be our names. For example, John Michael Doe styled as all caps, Janet Ann Wilson styled as all caps, and so on. 1953, we finally pay off the 1907 bankruptcy of the United States of America, Inc., but instead of returning the land patents owed to the actual states and people, those responsible pretended not to know who the land belonged to and rolled it up in giant land trusts, which they continued to tax, lease, rent, and otherwise benefit from our purported absence. 1999, we finally pay off the 1933 bankruptcy of the United States of America, Inc., but instead of returning all the Sesta KV estate trust assets owed to the living people, Bill Clinton signs Executive Order number 13037, stepping up the conscription process and again pretending that nobody knows who these accounts belong to, hoping to seize upon all our property, including our names, via a claim on abandonment. 2015. President Obama puts the United States, Inc., styled as all caps, and all its municipal franchises, including the Sesta KV estates belonging to Americans, into Chapter 7 bankruptcy liquidation. Almost as an afterthought, he puts the USA, Inc. into Chapter 11 reorganization. This effectively bankrupts the entire world. All the municipal government franchises doing business as, for example, China styled as all caps, France styled as all caps, and Lewis Allen Fulford styled as all caps. All the territorial government franchises doing business as Germany styled as upper and lowercase, United Kingdom styled as upper and lowercase, and Lois, Lilly, and Hardy styled the same way. 2015, Americans who have become aware of the fraud return to the land jurisdiction of their birth. The unincorporated government of the actual states and people doing business as the United States of America revives itself. The new government issues new sovereign letters patent for the states on November 4th and for the Indian nations on November 6th, and also issues an express trust. the Declaration of Joint Sovereignty. 2017, after extensive due process given to all the principal parties responsible, the liens against all the municipal and territorial government corporations and their franchises are completed and cured, including agricultural liens. January 6, 2017, a private registered indemnity bond covering all the actual states and people is lodged with the United States Treasury, and a payment bond is lodged with the Vatican Chancery Court. June 29, 2017, the American states and people, represented by the unincorporated United States of America, visit the United States District Court for the District of Columbia and claim back their property and assets as the paramount security interest holders and priority creditors of the bankrupt territorial and municipal government corporations and their franchises worldwide. That all brings us forward to the present moment. The One People's Public Trust foreclosed on the territorial and municipal corporations, intending to create a gigantic global version of the public charitable trust that they would then control. However, they are not the creditors. We are. We are the lawful owners of all that several generations of dishonest employees and middlemen have amassed, and which they have hoped to claim as abandoned property. The success of this scheme would have ended private property rights worldwide. The secondary creditors had already set up a plan to discharge the debts of the municipal franchises in bankruptcy via Treasury direct accounts. This process avoids the fact that these debts are all odious hypothecated debts that the living people never owed in the first place. It all avoids the fact that the living people are the actual paramount security interest holders who have been defrauded in breach of trust, and instead mischaracterizes them as bankrupt U.S. citizens. As our included public and judicial notice number 4 discloses, citizenship is a form of indentured servitude to the government of a country, and in the modern world it must be voluntary, proven, and equitable, or it becomes a form of peonage and enslavement outlawed worldwide since 1926. We maintain that the incorporated foreign governmental services corporations operating under color of law and purposeful deceit on our shores since 1868 have effectively enslaved our population and brought unsupportable claims against our land and our assets. We maintain that we are not and have never been subjects nor subject to bankruptcy proceedings related to these disreputable foreign corporations, and that we are owed the actual Constitution. We maintain that the municipal United States, styled as all caps, and the territorial USA practiced a form of genocide on paper against the American states and people, which is forbidden by the Geneva Conventions, and also practiced unlawful conversion of our assets, inland piracy, kidnapping, identity theft, and human trafficking against a peaceful third-party civilian population composed of their own employers and priority creditors. These actions by the United States and the USA against the American states and people are by definition international crimes of employees against their employers. We maintain that the bankruptcy of these foreign entities doing business as United States and USA on our shores has nothing legitimate to do with us or our property assets, and that they exist in a jurisdiction that is now and always has been foreign and separate from us. As the paramount creditors, we have stipulated to the court guidelines that must be met to establish proof of voluntary and equitable federal citizenship, without which no presumption of citizenship accrues to anyone born on the soil of an American state. In practical terms, this means that there are two classes of people to be addressed by the United States District Court of the District of Columbia. 1. Actual federal employees and dependents who are subject to the municipal and territorial bankruptcy and who are owed discharge of the debts of their respective franchises as part of the general bankruptcy, and 2. Americans who are likewise owed discharge of these bogus foreign debts via probate action, collapsing the municipal Sesta KV trusts and Puerto Rican transmitting utility franchises and other territorial franchises that had been created by federal corporations, infringing on their trade names without their knowledge or consent. So the actual federal employees are owed bankruptcy protection at the same time the American states and people, who are the paramount creditors throughout, are owed probate action, wiping away debts accrued by the secondary beneficiaries and the return of their land patents and other property assets without further disloyalty, obfuscation, claim, or delay. We direct the Treasury and the United States District Court for the District of Columbia to administratively reconfigure the Treasury direct accounts to recognize these two classes of people and the two necessary but separate processes, bankruptcy settlement on one hand, discharge through probate on the other, needed to clean up this mess. Now, and in the future, we require some sure and certain means to differentiate between federal citizens and the people of the American states. This can take the form of new identification credentials that would replace the use of state-to-state driver's licenses, except for actual federal employees, and proven actual dependents. We have no ill will toward our employees despite their incompetence and the destructive nature of their misbehavior, and will not object to them seeking bankruptcy protection. However, we insist that our assets are not subject to their bankruptcy and must be removed from the public charitable trust and returned together with the titles and land patents and other assets owed to the actual states and people. Discharge of odious debts, both in probate for Americans and in bankruptcy for actual federal citizens, can commence immediately to bring relief to both the creditors and the debtors, subject to creating a record-keeping process at the Treasury to identify members of the two separate populations and giving each their due. It is apparent that the plot to create one giant, all-controlling public trust for the entire globe has failed, and private property rights have been restored and retained throughout the world impacted by these corporate bankruptcies. The paramount security interest holders, the American states and people represented by the unincorporated United States of America, hereby willingly order the discharge of all similar odious debts owed to them by municipal and territorial franchises formed under the names of living people throughout the world. Read that. We aren't here to press claims of debt against little old ladies in Hungary or farmers in Zimbabwe or tradesmen in England who have been defrauded and conscripted and enfranchised just as we were under false pretenses and conditions of non-disclosure and deceit by their own respective governmental services corporation franchises. Let it never be said that the Americans are ungenerous or dishonest, despite the mischaracterization and criminal misrepresentation we have received at the hands of our own employees and the breach of trust we have suffered at the hands of our own international trustees for 6 generations. The release of all these odious debts held against living people throughout the world in all those countries impacted can commence as soon as it can be expedited by the Treasury and IMF officials. In the wake of this great debt restructuring and the enumeration and separation of the creditors from the debtors, we require that all the bankrupt bank franchises turn over their account records and prepare to negotiate terms with the actual asset holders, which are, for the most part, private historical trusts. It is not our will to cause any disruption or to move assets in any destructive way, but we will have an accounting of those assets owed to the actual heirs and trustees and beneficiaries of these funds, and we will have agreements with all the bankrupt commercial banks regarding access to these resources and these assets by the actual living owners for nonviolent and philanthropic and purely personal purposes. We also require a public accounting to be conducted throughout all sectors of the government that has been provided by the bankrupt government services corporations, state of, county of, and municipal entities, and their hired subcontracting agencies, beginning with the most recent annual financial reports, APRs, of agencies and departments and public trusts in each state, the most recent comprehensive annual financial reports, CAFRs, and of the state-to-state organizations. Our credit may be accessed to pay for these services, leading to an accurate public accounting for the first time since 1946. Thank you for your time, attention, and understanding of these urgent issues. Read this and over 800 other articles on AnnaVonReitz.com. Find the PayPal button and give generously.